Welcome to this panel. It's called The View from the State Bench, Judicial Campaigns and Public Confidence in the Courts. My name is Bert Brandenburg. I'm the Executive Director of an organization called Justice at Stake. We're a national nonpartisan partnership of more than 50 organizations that work to help courts stay fair and impartial and independent. And before I introduce our very distinguished roster of speakers today, I'm going to go through a little bit in the way of logistics in my role here as moderator. First of all, let me just ask that anybody who has a cell phone, in other words, all of you, please turn it off or put it on silent, because this session is going to be taped. And actually, I'll ask all the panelists, and I'll do this myself, we've been asked to turn ours off and not just to silent, because phones can interfere with microphone feeds. Okay. So I'm going to do that myself right now.
Mine in the room.
You left yours in your room. Perfect. So due to our tight schedule and the need to get you to other sessions, we are working to both begin and end on time, and so we'll work to finish right on the button at 12:30. When we get to the point where we have Q&A, we do ask you to wait for a microphone that'll be provided to you, and that your questions be both short and be questions when you come around to you. And then because this is a CLE eligible panel and has been approved for CLE credit, if you are interested in it and you have not done so already, you'll need to sign in on the attendance record, which is on the CLE table outside of the room, and you need to do that now. You'll need, as we finish, to pick up a certificate of attendance, and then there'll be an evaluation form you'll be asked to fill out and submitted. And I'm told to tell you that if you do not sign in, you won't be able to receive the credit. So, in terms of introducing our speakers, we have 5 different people who have been high court justices in America's state courts. The protocol of figuring out what order to do this in is rather difficult for me. I could have considered seniority, or maybe the population of their state, or maybe height. I will
start from the left.
Well, I got to be careful about that too.
To the left a little, Bert.
So I'm going to find a truly content-neutral way of doing this here and go alphabetically. Yes, exactly. Although someone may have written a law review article as to why that's not content-neutral, but I'm going to plunge ahead. So with us, and their backgrounds are in your program, they're all very distinguished, and I should say they're all people who I've had the chance to meet and work with, and you've really got a terrific roster here today of some of America's best. Justice Ann Walsh Bradley is Associate Justice of the Wisconsin Supreme Court. Justice Marilyn Kelly is Associate Justice of the Michigan Supreme Court. She's the former Chief Justice of that court. Justice Ruth McGregor is the former Chief Justice of the Arizona Supreme Court. Justice Patricio Serna is Associate Justice of the New Mexico Supreme Court. He also has served as that court's Chief Justice. And Justice Clifford Taylor is the former Chief Justice of the Michigan Supreme Court. So panelists, welcome and thank you. And what we're going to do, last year ACS did a session that focused on a lot of the problems that we're going to be reflecting on today, and they really focused on what are the problems going on with state courts and some of the concerns about what's been going on in judicial elections and the like. And the goal of the organizers this time was to sort of start from there and now focus on solutions. What can be done given the situation? So that's what we'll really be talking most about today. And yet, since not all of you may have been here 1 year ago and may not remember exactly everything that was said if you were, I'm actually going to start by doing a rather swift recap of some of what's been going on around the country and talk a little bit about not only what's been going on in judicial elections, but other possible sources of strains or weakenings in confidence in the courts. And then we'll go to our speakers in what we want to have be a very conversational mode here, to have them reflect both a little bit on the problems, but in particular ask them to think about the solutions. And each one of them has good ideas and good things they've done in their states and have seen a lot of things that are going on around the country that they can reflect on. So I'm going to set the stage here by talking a little bit about what's been going on over the last little bit more than a decade. For those of you who don't know, state courts are the way too often overlooked engines of justice in America. They handle something like 98% of all cases in the United States, and about 87% of all state judges have to stand for an election of some kind during their career. So there's a lot of electing of judges that goes on in the United States, and the United States is rather unique in that regard. It's the only country that elects judges in any substantial number. And over the past decade, these elections, which have been around to some degree in many states since the Jackson era, back in the 19th century, have been transformed. And I think the definition of what it even means to talk about a judicial election, about electing judges, has been changed. It's a different definition in the dictionary now. And in just a decade in high court contests, cash has become king. Justices and would-be justices must now raise millions of dollars from individuals and groups with business before the courts. So the judges are forced to raise money from the people who then appear before them, and then you have millions more spent by political parties, interest groups. Much of that money is undisclosed. This is all familiar terrain for anybody who's following Citizens United, et cetera. A lot of it was actually happening in the courts even before it exploded the way it is right now nationally. In the 1990s, for example, justices, when you add them up across the country, raised something like $83.3 million combined. The following decade, that amount more than doubled to something like $207 million. 20 out of 22 states that elect their high courts through contested elections saw their records smashed during this past decade. As an example of one race in 2004 in Illinois, Illinois elects its Supreme Court justices by geographic district. So you had a district in sort of middle to downstate Illinois, cuts its largest media market that it completely encompasses is Carbondale. It does touch St. Louis, and then sort of heads east through corn country and a little bit of coal country. You had in that race, the two candidates together raised $9.3 million. This was not even a balance of the court race. The winner on election night, Justice Lloyd Carmeier, said this is obscene. How can people have confidence in the system? This is the winner's speech on election night. This is obscene. And former Justice Sandra Day O'Connor has summed this up by saying, in too many states, judicial elections are becoming political prize fights, where partisans and special interests seek to install judges who will answer to them instead of the law and the Constitution. And we're at a point now where 3 in 4 Americans believe that campaign cash is affecting the outcome of decisions in the courtroom. Even more chilling to my mind is a poll that we actually did along with the National Center for State Courts, largest poll ever done of state judges in the U.S., some years ago, where nearly half of judges gave that same answer, that the judges themselves, nearly half of them believed that campaign cash was affecting courtroom decisions. That was nearly 10 years ago, and I find that to be a fairly remarkable number. There are, of course, other possible sources of weakened confidence in the system, and we want to get into this conversation here. There is the fact, of course, that there's plenty of disaffection with institutions generally in the United States, and there was a recent story that the quote-unquote official approval rate for the Supreme Court is supposedly at 44%. Historically, it's been higher. I don't pretend to know whether that's a blip or a trend, but it's out there. We, of course, have a steady diet of bashing the courts that goes on from both sides, politicians, bloggers, media talk show hosts for whom it's ratings to go after the courts, or you raise money if you're a political consultant. From the bench itself, of course, there's always the possibility that judges, other than the ones up at the table, may come up with bad decisions that are wrong or unpopular for the right reasons. And of course, judicial conduct is always under the microscope. Judges, on the whole, are very ethical, but if they have the slightest transgression, it gets magnified. So a judge who gets a traffic ticket gets a lot more ire than somebody else who gets a traffic ticket. And of course, judges are famously and constitutionally insulated from a lot of politics. They are given an independence in our country that other political figures are not. That could well lead to extra disaffection. And this is an era of increasing political rancor, and why wouldn't it be spilling over in the courts? So I throw all of that out to say that there could be a lot going on here, and I'm hoping our panelists will mix it up and both talk about what they think the problems are. And what I'm going to do is start going through, again, alphabetically here to begin with, and ask each of them sort of a short question and a little bit of a longer answer question. And the short question will be, what do you think is the biggest problem affecting confidence on the bench? And then I'm going to ask you a specific question about an idea you may have for making things better. So I'm going to start with Justice Bradley and ask the first question. First of all, what do you think is the biggest problem affecting confidence on the bench?
The biggest problem is the perfect storm that we're in. Now, I answer the question that way so I can talk about two things rather than one. It's a combination, of course. The perfect storm is that we have unlimited and unaccountable money coming in rapid pace at a time when hyper partisanship, and I mean that with both a big P and a little p, a big P for the parties, a little p for other special interest groups, is at an all-time high. Couple of points. One, just to put what Bert said with regard to the state of Illinois. I'm from Wisconsin, and I have had, I guess, the pleasure of having a front row seat in seeing some of the issues that are evolving and we are discussing here today, and sometimes it's been a little less pleasurable. But what we have in context, states south of us, Illinois, Bert said November of 1994, that race, they elect by district, their Supreme Court, 29 districts in southern Illinois, as Bert said. But let me put a little more context on that. That was November of 2004, 9.3 million. In 2000, in the year 2000 in Illinois, there were 3 Supreme Court races up. And not one of those Supreme Court campaigns ran a television ad. Not one. In 2002, there was one contested Supreme Court election. And I think in total, the campaigns spent a little over $300,000. 2 years later, 9.3 million. So we have a problem on our hands that's of relatively recent vintage. Bert also mentioned the recent New York Times poll that talked about the approval rating of the United States Supreme Court at 44%. Again, to put it in context, I think when I took the bench in the High Court in Wisconsin, the approval rating of the United States Supreme Court was at 80%. And it has fallen to this depth. Another recent poll, the Pew poll, some of you may recall, just came out earlier this month, that indicated that we are at an all-time high for hyperpartisanship. And I think, Bert, that hyperpartisanship in terms of the political parties, with the big P, as I said, and the special interest groups, puts the high courts in the various states really in the crossfire of the battle that's being fought between those special interest groups. And we are, someone said to me the other day, we are but pawns in the chessboard. I hope that's not true, but at times it feels as though it is.
So your answer to what the problem definition is, it's the combination, the storm, you said, of money and TV ads and partisanship in terms of what to do and the solution set, is therefore campaign reform? Is that an answer, part of the answer?
Several answers come to mind. Campaign reform, not easily done, and we had it in Wisconsin in 2009, a special focus on judicial campaigns and limits, 100,000 for primaries, 300,000 for the general election. First election that was tested in was 2011, and it didn't work.
And this was a public financing campaign,
That's right.
right?
Mm-hmm.
Okay, so
Yes.
for
Public
those who may not be
financing,
familiar,
I'm
this
sorry.
was, so the judges each got the amounts you're describing.
Yes, thank
Okay.
you. And it didn't work. It didn't work in this sense. The parties, at least initially, abided by those limitations, but the special interests came in and drowned out the spending, multiplying what the parties spent by 4 or 5-fold easily. So although you may limit the parties in terms of those who are running with some kind of campaign finance reform, until we're able to address the special interest, it's really not accomplishing much in my mind. It was unsuccessful in many ways, and the legislature repealed that law a few months ago.
And I recall when, some years back, when at the time all the members of the court unanimously signed a letter saying they wanted the system. Do you think that would happen again if the legislature was in a position to consider it again?
No.
No. You think anybody would sign it?
Oh.
You would, okay. So you still believe in it. You have concerns with it, but you believe in it. What would you want it changed, done a different way?
I believe in it in the sense that I think it's important to have some controls, but I'm not so naive to think that it is a full answer. until we are able to come to grips with perhaps more meaningful and constitutional disclosure laws with regard to special interest groups' expenditures, putting limitations. Again, we've got a lot of constitutional issues. I don't mean to slide over them easily, but I think that if there cannot be meaningful finance reform with meaningful disclosures on those who are not regulated, and I think we in Wisconsin will have to take a look about how we are selecting our judges. I say that so hesitantly because there is a certain populist approach that's in my blood, which calls for election. But our elections aren't working.
Thank you. And so we have a fortuitous transition by alphabet here because Justice Kelly from Michigan is in a state whose profile in terms of judicial election issues actually has a lot of similarities to both what's been going on in Wisconsin and Illinois. We've seen a lot of similarities between a number of the industrial Midwestern states. And so, Justice Kelly, let me ask you first of all, as I asked Justice Bradley, how would you define what you see as the main problem affecting confidence in the courts?
I couldn't agree more with Justice Bradley, and you're absolutely right, Bert. We have great similarity between Wisconsin and Michigan in the problems that we've been facing. I believe that we must have campaign spending reform. We must find out who is contributing to these ads that are so nasty and often inaccurate that come up during these campaigns, and let the people know, make a full disclosure of the information about it. We're concerned in Michigan also about hyperpartisanship. We're the only state in the union where our justices are nominated by political partisan conventions and then elected as nonpartisan candidates at the general election. That obviously infects the process with a partisan component that is hard to deny. And it's caused, I know, distrust and concern among the public. We have tried to make some corrections to these problems in our state, and I'll be happy to talk more about those.
Please do, and in particular, we're fortunate with Justice Kelly here that not only does she have a solution set here to talk about that came out of a task force that she was very involved in, but I'd also be curious to have you talk about just the politics of approaching this with a task force model and what you think, how you did that and why you think it was perhaps the right way to go given the particular problems you faced.
Right. I'll go into more detail than you'll ever want to hear if you give me the opportunity here, so I'll try to keep it brief. But I was inspired by Sandra Day O'Connor's interest in improving the courts. And at the urging of some attorneys in the state, I sat down with a former federal judge, James Ryan, who used to be a justice on the Michigan Supreme Court, and went from there to the Sixth Circuit Court of Appeals, where he served honorably and recently retired. Now, he's a conservative, I'm a liberal, and we decided together that if we could bring together, and we did, 24 people who were half conservative, half liberal, some lawyers and judges, but many others, business people, educators, people who've been in the legislative branch of government, bankers, others. If we could get that group together with absolutely no predetermined result to this study, we could, and if we did, made an honest effort to study, which we did for a period of a good 6 months, study the problem and then come out with solutions, that it might be the most valuable and credible study that could be done in the state. I'm pleased to tell you that both Justice Taylor and Justice McGregor were good enough to come in and make presentations to the task force when it was in its study phase. And also we were funded by neutral groups like the State Bar Foundation, the Mott Foundation, the League of Women Voters, a local law school, Wayne State University, made facilities available to us free of charge. So there was no funding or support for this that came from an interest group in the normal sense of the word. So we spent over a year doing this, and just recently came out with a report, which is available to you on the internet. This is what it looks like in the flesh, but it's available at mi-judicialselection.com, and I think there are some partial copies of the partial report available to you here. We came up with solutions, recommendations, and we actually attached in the appendices proposed legislation, proposed constitutional amendment, proposed executive order, various things which could be concrete applications of the recommendations.
And do you want to talk a little bit about what the highlights were of those amendments and legislation that you recommended?
Sure, I'd be glad to. Well, number one was, of course, campaign finance. And we agreed with, I think, what you heard here from Justice Bradley, that we need to adjust the Michigan campaign finance laws to identify where spending for Supreme Court races is coming from. And I don't just mean the name of the organization like Citizens for a Better Supreme Court. I mean actual knowledge of the donors by name and the amount of the donations. And all of that reported in a timely manner so that the electors can see it and digest it before they go to the polls. We also recommended doing away with this strange procedure Michigan uses for nominating justices, go to open primaries, nonpartisan primaries for those justices, just as we do for all the other 610 judges in the state. We recommended, one of the things we were concerned about was the large number of people who go to the polls to vote who don't vote for judges. Why don't they vote? Maybe 25 up to 33% don't vote at all for judges. Charitably, it appears they do it because they simply don't know enough about the candidates to feel they can make an informed choice. I choose to believe that rather than that they don't care about the judiciary. But certainly they need more information, not only about the candidates, but how the system functions. We believe there should be a better effort at informing the public through, for example, a really good voter's guide. And so we recommended ultimately that the Secretary of State include a good voter's guide on her website. If the money were available, these being bad times, it's not, but if the money were available, we'd like to see something in writing in the hands of every prospective voter in the state before Election Day. Another change we recommended was that when there are vacancies on the court, in Michigan they're filled by the gubernatorial appointment. Many, many justices have taken office, nearly half, initially by appointment of the governor. Lucille Taylor is here, and she's the wife of Clifford Taylor, and she was instrumental in working on advising Governor Engler of candidates to fill these vacancies. And certainly a good effort's been made for the governor to do a good job in that. However, in Michigan, there's no check or balance on the gubernatorial appointments to these vacancies, and the system used is not transparent in any way. So we have recommended that the governor agree to use a nonpartisan commission that would make recommendations and would do it through a very public procedure, one such as is used in other states. So the public would know who's being considered, what their qualifications are that are used by the commission to ultimately come up with a recommendation to the governor of candidates from whom the governor could choose to fill a vacancy.
And the recommendation would be binding or non-binding?
Ideally, it would be binding if it were to have a real impact. Now, we came up with several other recommendations, but those are the major ones. What's important to realize is that these recommendations were the consensus of the entire group, so that we had no dissenting views expressed in any kind of a statement. We had great difference of views on many of these issues, and we talked them through. I was complimented to hear one observer of our process remark that it was as true to a textbook-type democratic process as he had ever seen, where people genuinely disagreed, talked out their differences, made some negotiated compromises, and ultimately came out with a consensus series of recommendations. We're very proud of that. One other thing I'd like to mention, I don't have to do it at great length here at this point, however, is I believe that one of the major flaws in our system in Michigan has been that we've had no system by which a justice who's asked to recuse himself or herself and who refuses to do so can be challenged. All the other judges in the state are subject to an established procedure in Michigan whereby a refusal to recuse can be appealed. That has never existed in Michigan until just 2 years ago when I was chief. We were able to pass a recusal rule that does allow the other justices to be petitioned to vote to recuse an unwilling justice. And that rule has been in effect now for over 2 years in Michigan, and I can talk more about it later, but it's been functioning well, and I think has helped to increase public trust and confidence in the system.
Thank you. And actually, a number of the points you raised substantively, I do want to come back and have us talk about together. I want to actually stay on the politics of the task force model for a moment, and in part because we want to get conversation going amongst us all here, even as we go panelist by panelist. I'm going to ask Justice Taylor, who's also from Michigan, just on the specific question of the task force model and the approach that was taken, what your thoughts were on that, given that you're in the same state and have a lot of experience in politics there as well.
Well, I don't share the level of enthusiasm about what the task force did that Justice Kelly does. I think the heart of the task force was moving towards merit selection. And as Justice Kelly says, many of the people on the committee, I'm not quite sure how many, but a good number of them wanted to have binding merit selection. I think this misunderstands what happens in merit selection. Merit selection is, of course, billed as a system which will be one focusing on the credentials of the applicants for the judicial position. So it will be a credentials-driven process. It is the case that this process is for the Supreme Court, as I understand it, and would not be used in lower courts. That having been said, it's important to understand that bums don't apply for the Supreme Court. That is, the credentials are a wash. Or if they're not a wash, you get into sort of a ridiculous situation where you're saying that one applicant had a 3.5 at a given law school 40 years ago, and at another law school, another applicant had, let's say, a 3.4, so I guess the 3.5 is more qualified, and that's kind of a ludicrous proposition. So you can't do the dividing based on credentials, the division of the House and the division of the candidates. So what happens? I think the default is to go to policy positions. How does the applicant feel about sexual liberty matters? How does the applicant feel about abortion? How does the applicant feel about things which I think most everybody would agree in the United States are sort of partisan political issues that have sort of morphed into judicial hot-button issues. So I think what will happen with merit selection is not a search for credentials, but a search for people who agree with the committee on policy matters. The other problem with merit selection, and of course that's not what should be happening. I mean, that is not a good situation, because if we want to have it be on policy matters, there ought to be some place that people get a right to say if this is the policy they share. And so other systems, such as gubernatorial appointment with legislative confirmation, or elections, are the alternative, which allows for some public accountability So I'm not an enthusiast of the committee's findings, and I would just simply say that if you are truly interested in democracy at stake, then you ought to be very nervous about merit selection because it deals the people right out of the process.
So I think the topic of merit selection has now been officially opened here for discussion, and I think what I'd like to do is actually just continue this thread. And we, as it happens, we have two justices here who have served within systems that have merit selection for some or all of their selection. And why don't I turn to each of them and ask them to start reflecting, and then maybe even Justice Kelly, you might have thoughts to say about the debate that went on in the task force itself. So Justice McGregor, do you want to
Sure.
comment on what you're hearing about merit selection?
Sure, and let me just say, with regard to the problems that we see in judicial campaigns, I think the main ones have been pointed out. They're much more expensive than they used to be. Bert mentioned the financing of them is much more concentrated. This is something that I think that we really need to be aware of. In the last round of judicial elections, something like 40% of the spending, of the financing of those elections, almost 40, 38.7, came from a few, like 10 super spenders. And these are not the candidates. They're not their organizations. These are the outside groups who come into various states. And this concentration of financing, I think, is something that should be of major concern for us. I think the increasingly negative tone of judicial elections makes them very different from the way judicial elections used to be. And the fact that some of these problems are spilling over into retention elections in merit selection states is a problem. Given those, I think we make a real mistake if we just don't recognize that there are problems with judicial campaigns. You've already heard talk about the reaction of the public. Almost 3/4 of them think that judges are influenced by campaign contributions, and lately 50% of the judges. Now, if that's okay with all of us, then we just say, we stick our heads in the sand and say, just let the campaign financing go on in our judicial elections. But if it's not okay, I think we really have to look to see what can be changed and whether this produces what we want. I don't think that it does. I think there are things that can help things we've tried, public financing, better recusal rules, committees that try to keep the ads fair and safe. But in the end, I don't think that we can fix judicial elections. I think what we've done is make them more and more politically partisan, and we require our judges to go through those partisan procedures to be elected to take the bench, and then we're concerned that our judges are political. I mean, let's really not be naive about what we're asking. To ask a judge who has to raise money and get support of special interest groups and political parties to then be able to be fair and impartial is possible for some judges, but the public simply doesn't believe it's true. What's the alternative? Justice Taylor and I have talked about this before. Arizona has had merit selection since 1974, and all the criticisms I hear actually have ways to be dealt with in merit selection. Central to merit selection, an effective merit selection program, is a really effective nominating commission. This is what makes merit selection work or not. We have a 16-person nominating commission, 10 public members drawn from all across the state. It's politically balanced, 5 lawyers, again, politically balanced among the lawyers, with everything transparent and open. From the time somebody files an application, it's posted on the web. All the work of the commission is done openly, in public. Public comments are taken. The reports of the commissioners and their investigations are public. The discussion of the applicants is public. Interviews of the applicants are public. The voting on the list to send to the governor is public. We try to make this as transparent as possible because there were, in some states and earlier, I think in Arizona, valid criticism that this was kind of a backroom policy, and you just took the politics out of the ballot box and put it into what used to be a smoke-filled room, no longer. And so we've made it very transparent and open so people can see. that we do have retention elections, and it's one of the areas I have some concerns about. We've never had a serious challenge to somebody in a retention election. You all know what happened in Iowa.
Do
But
you
here's-
want to clarify
yeah.
the difference between a retention election
Yeah.
and a competitive election?
Yeah, thanks, Bert. In a retention election, which is used in most merit selection systems, after usually 2 years and then the next general election, your name goes on the ballot. Should this judge be retained in office, yes or no? The voters decide. In Arizona, it's a simple majority that have to vote yes, which really means that in many states with elections, nobody runs against a large percentage of the judges, so they're automatically reelected. We all have to be approved by the voters at the end of our term in order to be there for a second term. The question becomes, what if somebody gets off the bench? Supposing a judge is defeated in an election state or not retained in merit selection state. One of the big differences is the person in a merit selection state who takes the bench has to go through the nomination process. That person has to be vetted by a commission that hopefully looks for the qualifications that make somebody a good judge, instead of being defeated by somebody who happens to have a little better political name or something of the sort. So one of the big protections in merit selection is if a retention election, if somebody is successfully removed from the bench, we have the protection of the commission and choosing the best candidates to go to the governor, that only those persons who make it through the commission process can be nominated to be a member of any of the courts.
So I'm curious, in terms of the process and how it's actually worked. Justice Taylor said he felt his concern was that the credentials, part of it would just be a wash, I think was the phrase you used. What's been the experience in Arizona in terms of how the credentials or what factors go into the selection?
Yeah. Well, when I happened to start practicing in Arizona the same year that we adopted merit selection. So when I started practicing in 1974, all of our judges were elected. And they were grandfathered in, so gradually the bench changed. And it was a huge change. In election systems, you have some really great judges. I mean, that was the same fall that Justice O'Connor was elected as a trial court judge in Arizona. So you have some great judges. But at least in Arizona, and I think in most states, if they're being honest about it, you get some real clunkers. You get some people that, if you are a lawyer and you get assigned to their courtroom, you just think, oh my God. Because you know that the judge will not work very hard, maybe doesn't have the mental capacity to understand very well. So what merit selection has done for Arizona is it's given us a really high bench without any of the real low points that I think can happen in an elective system. I think it does make a difference in the overall quality of the people who come to the bench. And it may not make so much difference for the Supreme Court, but I think for the trial court it makes a huge difference. That's been our experience.
Bert?
Did you want to add, please? Yeah.
Yes. Coming from Wisconsin, where we are selected by election, I've always bristled a bit when the contrast is between an elected system and a merit system, as though those who are elected
Have no merit.
have no merit, you know. And
Yeah.
so those aren't the phrases that I use. Let me just say, by summary, that I don't care if you get to the court by election or if you get to the court by some kind of selection, appointment, going through a commission, retention. What you don't get, I don't think, better judges or worse judges. I think sometimes people talk about to be a judge, you should either know the law or know the governor, right? Then in one you know the governor, and the other you might know the law, and you get the same kind of combination, whether it's going to be, you select judges, in my opinion, from election, or if it's some kind of a retention sort of process. What we need, I always say, and I say it here today, is we need judges of courage. That's what we need mostly. We need judges who are willing to stand up to the political winds of the day. And whether it is through election or some other process, that's what you get. That's what you need. And so I think the debate about what we're going to do in terms of should we select judges one way or the other, I don't think you get better judges personally. I don't think you get better judges through either method of selection. And I know I was not all that long ago with the Chief Justice of Missouri, and when we talk about retention, It's the Missouri plan that oftentimes is the base. And of course, she and her state were under attack that the retention method was highly polarized and partisan. And I'm not sure that's true, and I'm not saying it's true, but that, you can always subject to attack. So I think that judicial elections have to be re-examined, not because they give you better or worse results, but because of what they are doing to the eroding the public trust and confidence of the people in this court system, and they are being subjected to the corrupting influence of money. So to me, the debate has nothing to do, or very little to do, with who's the better judge that's going to, or who's the better judge.
Yeah, and this is always difficult with judges, I think, to talk about. And the term merit selection may be a bad term. I mean, I tend to use nominating commission retention rather than use it, but I think most people refer to it as merit selection. But I do think, and I hope my comments made this clear, I think the biggest problem we have to deal with is the public attitude toward what they see as the corrupting influence of campaign finance on electing judges. And that has to be our biggest concern, because we depend upon public trust and confidence in our courts. And one of the ways we can do away with that financing and the thing about judges need money to take office is to use a nominating commission form where judges don't campaign, where they don't have to raise money, where they don't come to the bench as a result of the expenditures of their own committee or outside influence groups. And I do agree that that's the big issue that we're dealing with.
So, Justice Serna, you've seen all of this, because New Mexico, number one, if I'm not mistaken, has different forms of selection for different levels of courts, which is not unusual around the country. It's a big patchwork when it comes to systems. But in addition, or I should say in particular, the Supreme Court in New Mexico has a hybrid system that involves not only it involves a combination of contested elections and merit selection and retention elections. And so you've seen all of this for years. What are your thoughts in particular about merit selection as we're debating it here?
Well, first of all, I think that we need an independent judicial branch of government in order to preserve our freedoms, our liberties, and justice. And with these millions of dollars being poured into states, that takes away that independence, and of course the perception, take away the trust and confidence of the public in the courts, and rightfully so. I'm proud that in New Mexico, number one, we have public financing of the Supreme Court race, the Court of Appeal races, and recently we had a primary election, and one elected to go public financing. The opponent didn't. The opponent raised more money. We do have matching, and they matched it. It didn't come to the Supreme Court because we might have had to have declared it unconstitutional based on the Arizona case, but the Secretary of State just provided the matching funds, and the district court upheld it. And of course, we were so glad they didn't come to us, because we might have to undo it. But at any rate, the hybrid is that we have a judicial nominating commission, equal number of Republicans and Democrats, non-attorneys, attorneys, judges of that particular court. And they screen, and they have standards and guidelines, procedures, all transparent, everything's open. And the names are sent to the governor, and the governor appoints from that list. And if the governor refuses to appoint from that list, then the Chief Justice appoints. And I've been on the court 16 years now, and twice the Chief Justice has had to appoint because the governor refused to appoint. And of course, the Chief Justice appointed someone that had been recommended by the Judicial Nomination Commission. Now, after that person is appointed by the governor at the next general election, he or she has to run on a partisan basis. But we do have public funding.
And that's against an opponent.
Yes.
Right, so that's
Oh,
the
yes,
hybrid.
partisan.
As opposed to a retention, that's a competitive
Yes,
election.
no. Once you win that first partisan election, after you've been appointed, thereafter it's by retention. And you don't have an opponent, they vote yes, they vote no. Now, the way it worked with me, and proves your point, but also proves Justice McGregor's point. I wanted to be on the Supreme Court, and I'd been on the district court for 12 years, but I didn't even bother to apply to the nominating commission because I knew for a fact that that governor would not appoint me. And so I said, I'm going to go to the people. And I did. And I beat the one that the governor appointed. But I went the extra mile. I even had a Green Party opponent. Otherwise, it would have been a supermajority. As it was, I only won by 1%. And thereafter, I went for a retention election in the year 2000 for an 8-year term. And I didn't spend one penny. I didn't campaign. I just did my work. And I was retained by 75% of the vote statewide. Some parts of the state, I got even up to 90%. Other parts, lower, because our state, has geographical regions. And in 2008, I ran again for retention, and again, I got 75% of the vote. And so I was pleased, because that had been my goal. Now, we haven't had the super PACs coming in for judicial elections. They are coming in big time for congressional elections and even for some state legislative elections. But thus far, they haven't come in for retention elections. In some states they have, and you've seen the devastation in Iowa, although they could have fought for it instead of sitting back. And I certainly would not have sat back. I'd have gone out again to the people. But at any rate, this judicial independence, Benjamin Franklin said when he was ambassador to France, when I think of liberty, I think of my country. But if we continue down this road where elections are for sale and you don't even know who the donors are, and you're losing the public faith, trust, and confidence in the courts, my gosh, Benjamin Franklin wouldn't be able to make that statement. So I just hope that we turn it around. And have included it, so I hope you heard my words in the back, did you? Okay.
Thank you. So Justice Taylor, you wanted to add in here?
Yeah, I'd like to take a run at this. Why is so much money all of a sudden over the last 20 years coming into judicial races for the high court? I think it is really simple. I think it is because the partisans, the people who have policy goals for the society, pro-life, pro-choice, sexual liberty, whatever it might be, same-sex marriage, why are those folks all suddenly focusing on the courts? labor, business, to complete the groups, I guess, because they think the courts are doing what heretofore had been thought of as legislative work. The courts are muscling out the legislature. That's the simple reason. I mean, everyone talks about how lamentable this is, and maybe it is, but I think the reason is simple. The reason is that the people who care about policy goals, who used to lobby the legislature, now are lobbying the courts through the vehicle of money. And I don't think there's a single better example than the recent Wisconsin Supreme Court election, where Justice Prosser ran against, I think her name was Kloppenberg, if I'm correct. Now, all of us followed that election. It was hugely covered. What do you think was at issue? Why did the partisans put so much money in there? Because the expectation was that if Kloppenberg won, she was going to be the deciding vote to kick out Governor Walker's reforms. Classic political kind of interest. Similarly, in the state that I'm from, Michigan, there's a great dispute in the state about the two great schools of judicial thought, textualism versus the living Constitution, if you will, sort of Scalia versus Brennan. And if one or the other of those schools prevails and controls the court, you will get different kinds of decisions. You will get decisions which are much more modest in terms of judicial power grabs if the conservatives take it, and you'll get, it's expected, much more aggressive judicial policy making if the left takes it. That's why people are spending money. It isn't because there's something evil or something. They're just doing what Americans have always done. The money goes to where the policy gets made. One other thing, if I might, much is made of this poll which says cash affects court decisions. First of all, I'm not quite sure what affects means. I mean, it might mean skews them or causes them to be different than they would have ordinarily been, but I'm not quite sure that all listeners to the question, when polled, would know that, but let's assume they do. Would they say something different if they were asked if money affects the actions of the executive in their state or the legislative branch? I think they would say, yes, it does. So it's probably not dispositive of whether or not they want to go to a system that deals them out, that is, merit selection or some variant on that. And if, in fact, merit selection is such a good idea, and if they feel that it affects court decisions, governors' decisions, legislative decisions, do we want to do merit selection for governors? Do we want to do merit selection for the legislature? Well, I ask you this. What you are hearing here is an assault on the people having any role in who becomes a judge. Look, maybe elections aren't the answer. Maybe they are too complicated for people to follow. But it just can't be the case that we subcontract out to a group of nice people who are going to be our judges. It is just a bad idea. In fact, Justice Cerna talks about, if you followed his story, he got to the bench by asking the people. He now apparently is in a position where he doesn't have to ask them anymore. I'm not so sure that as the courts have begun to do policy, that we really want to take the people out of it. And I think if you wonder about this, I would refer you to the Constitution 2020, which was a group of liberal academics who got together to say what they thought the Constitution would be in the year 2020. Really aggressive policy making by courts was anticipated. Now, I think a lot of what is going on here is they want to be immunized from the people stopping this. And I think people need to be aware of that who are in the general population.
Justice Bradley, I actually want to go to you first, and I know others want to speak as well, because you in Wisconsin were in the before and after, because Wisconsin actually, although this has now become a problem in a number of states, it was only a few election cycles ago that up until that point Wisconsin had been pretty quiet in this regard, even as other states next door, Michigan and Illinois, were having a lot of problems. So you've seen it before and after. What are your reflections on the why, and Justice Taylor has given a theory, and also then obviously some of the comments about the reforms? Because you said you're having a little bit of an epiphany.
That's right. Well, I've been blessed with coming from a large extended family. I've got lots of cousins, and I got lots of cousins who have lots of children. And I'll tell you, when I go to my family reunions this summer, there's not going to be one of them that's going to be talking about textualism versus a living constitution. Not one of them is going to be talking about that. Now, why are judicial elections facing such a traumatic situation right now? A lot of reasons, and I think what we were just discussing about some of the more sophisticated, if that word is appropriate, and I'm not sure, groups are thinking about that. My cousins aren't, but some groups are. But another reason money comes into judicial campaigns is one of the reasons that all of us are kind of interested in this topic. It isn't just Citizens United, it's that Caperton case. And all of us know the Caperton case that came from West Virginia in the November of 2004 election. And I'll tell you why that campaign and that election ended up the way that it did. I don't think it had to do with textualism. I don't think it had to do of those who want to embrace a living constitution. I think it pure and simply had to do with a $50 million punitive damage verdict against Massey Coal Company, and it was a darn good investment to invest around $3 million to get rid of an incumbent justice who you thought would likely vote against you. I don't think Don Blankenship was talking about textualism versus living constitution. I think he was talking about $50 million punitive damage award. So I don't mean to suggest that isn't part of it. Textualism versus living constitution isn't part of it. It is, but there's additional components also. So that's my initial response.
Thank you. Let's get a couple of thoughts from the justices, and then I would like to open it out to the audience. So those of you who may have questions, if you want to start raising your hand, asking for the microphone, they'll be given to you. So Justice Kelly, you wanted to add in?
True, just a few observations. I hear at the base of what you've heard from Justice Taylor, a plea for a weaker judicial branch of government. For sure, I agree with him. Courts can go too far in setting policy. Courts can intrude on the prerogative of the legislature. But surely, we recognize that over the course of the history of our country, courts have made policy upon occasion, and in many occasions, thank heavens they did. We know that judges occasionally are the last hope for a decision that effectively a legislative branch refuses to make. I think it's crucial that we distinguish between the role of a judge and the role of a legislator or a governor, a person in the executive or legislative branches. The role of a judge is to be impartial, not only to be impartial, but to be viewed as impartial by the people out there. If the people don't believe that judges are able to set aside their own views, whatever they are, and make decisions fairly, our government simply can't function. It's a basic rule. Therefore, the procedure used to elect or select by merit judges has to be approached differently than the system we use for governors and for legislators.
Justice McGregor.
Yeah, and following on that, I really encourage us all to not get too caught up in elections versus merit selection. I mean, that might be the final place we come to as a decision, but one of the points I'd like to make is I'd like to ask us to step back and say, what kind of person do we want as a judge? And once we define that, then we can move on and say, what is the system that is most likely to produce that? I think we actually mostly agree. I think we want people who are learned in the law, but still willing to learn. Think we want people with integrity and a good sense of ethics. And we want people who are fair and impartial and open-minded. And we want people who can run their courtroom well. These kinds of things I think we agree upon. And once we take those and look also at what kind of court system we want, then we can ask ourselves, how do we get those people? What's the best way for us to think that that's the kind of person who will be on the bench? And I don't think the answer is just elect them the same way we do our political branches of office. I'm on the board of Justice at Stake, and I'm also on the board of the Institute for the Advancement of the American Legal System, ILS, in Denver. And outside, I think you'll find the cornerstones of state judicial selection, which doesn't speak to one particular form of selection, but talks about taking this view of what kinds of people we want on the bench, what we think the good characteristics are, how do we evaluate people as to whether they exhibit those characteristics both before they're selected in some way and after they're on the bench. And then regardless of the system, what can we do to make it more likely that we do that? I think that that is in many ways a precursor, a conversation we have to have before trying to decide what situation or what method we want to get behind. Let's decide where we're going before we decide how to get there.
Justice Serna.
I also am on the board of the Institute for the Advancement of the American Legal System, and we do have a wonderful strategic plan regarding judicial selection and so forth. So I urge you to look at it, and we're trying to work with different states to go into the quote-unquote merit system. And we should never forget that we also need diversity in our courts. Now, in New Mexico, 3 out of 5 members are minorities. And that goes a long ways, because you need leadership from the top to spread that diversity throughout the judicial system, such as in the Board of Bar Examiners. Oh, the diversity we have there. And you need it on the judicial selection commissions, the judicial performance evaluation commissions, because everybody deserves a place at the table. And I'm on the board, and so is Justice Kelly of the National Consortium for Racial and Ethnic Fairness in the Courts. And we are making major efforts there to get that diversity in our judicial system, because it is needed and it enriches the system.
Thank you. So let me ask, is there a first question from the audience? I don't know if somebody already has the microphone, or why don't we start over here? I saw a hand and up in the front. Oh, I'm sorry. You had the microphone. I'm blinded by these lights here, so you just got to tell, yeah.
But so you've spoken a lot about the influence of money in elections kind of at the beginning stage. And I'm concerned about elections after somebody's already been appointed, retention elections, recall elections, the influence of those things on the judiciary now that there is more money involved, where, you know, from the time I was young, middle school, when I learned about the role of the courts in our system of government, in protecting minorities and minorities' rights against the tyranny of the majority, both, you know, in the sense of me being a minority and being very supportive of the notion that the majority who did not like me could not do certain things to me, and the judges were there to make sure that didn't happen. And minority in the sense of those who don't have a lot of political or economic power. I'm concerned about that influence on the decisions of judges who are actually sitting, who know that their protecting those minority rights is going to influence what happens in this election coming forward, where they're going to have to go and raise money from these interest groups. And that, for me, gives me tremendous concern about my understanding of the role of the judiciary from the time I was very little, was not a judge, learned this stuff in public schools, and, you know, what that says about what happens to folks who are not, frankly, necessarily like me anymore, but like who I was when I was younger. So I'm hoping that you could speak to that.
I'd like to encourage my colleagues on Supreme Courts, not only here but throughout the nation, that states have to start relying on their state constitutions to give more rights. We can't give lesser rights than are being given by our U.S. Supreme Court, and let's face it, they've been eroding the rights of minorities and of all citizens. But the impact has been on minorities. And so we are in the forefront of giving broader rights under our state constitution than is being given under the federal constitution. And some states are in lockstep with the federal opinions. And that concerns me and that bothers me, because we can rely on our state constitutions. And I try to speak to justices throughout the nation to please do that, because when our top court lets us down, let's rely on our state constitutions.
Did someone else want to add to that?
Yes.
Justice Kelly and then Justice McGregor.
I think it's an excellent question, and one that many people I know think about. I know during the period that the 24 years I've been on the bench, I've frequently had people ask me how I managed to take, or my campaign committee takes money from people who appear before me in court, or lawyers who argue before me in court. How do I take that money and then not let that influence my views? And I've tried very assiduously to explain that I have a system whereby I do not consider any campaign contributions or future possibilities of campaign contributions when I make decisions. And I argue my best, and I often get very sincere nods in reply, but the fact is I don't think that it's believable to people, especially people who haven't been judges and experienced this. One reporter recently wrote that to expect that a judge isn't influenced by campaign contributions is like to expect when you put 4 quarters in a vending machine that you may not get that candy bar that you ordered. To many people, it just doesn't appear possible. And the problem I see there is that if the people don't believe that judges are capable of being impartial, given the effect of big money on judicial elections, how are the people going to trust that judges are really independent? It's a fundamental problem.
Justice McGregor.
I agree. It's an important question, and in fact, there are some studies that indicate that, looking particularly at judges upholding the death penalty, that there are changes in behavior as an election is coming up, retention or contested. One of the things that I think judges can do, that the system can do, and that's proven helpful to a number of judges who were coming up for a retention election with a group coming in and challenging the judge, you're fortunate if you're in a state that has a formal judicial performance evaluation system, where your performance, according to the criteria that people have decided are important, is evaluated throughout your term. This happened to the Chief Justice in Alaska, who had gotten really positive performance evaluations for many years. At kind of the last minute, somebody came in to try to challenge her in the retention election, and she was able to point to these evaluations that had been done by people who actually appeared before her and actually worked with her, and show that her work as a judge had been very good, her body of work. So I think that that's one way that we can, as judges, we can have our judges evaluated so that they have something to turn to. But it's a difficult issue, and I totally agree with Justice Kelly that even though we believe, I think we really do, most of us, that we make our decisions impartially, when you say that to the public in general, you just see a certain amount of disbelief, I think. And that's reflected in the polling, too.
So let's go to a second question, and I'll pick someone out, and let me just ask after that, just because I'm having a hard time even seeing hands, is after we do this question, I'll actually ask the person on the microphone to go ahead and identify people, and we'll try to switch back and forth. But let's take one more person on this side over there.
I need a microphone. Child. I'm Janet Varnell from Florida, and in Florida we have a merit retention selection coming up. We have an unusual situation. I don't know if all the panelists are aware, but about 8 months before our election, there was a very bold statement made that they intended to unseat 3 of our sitting Supreme Court justices. So my question to you is, what is the appropriate role of the Florida State Bar when we are faced with these unprecedented outside spending campaigns against our sitting judges?
Anybody want to start? Justice Taylor, were you leaning forward to?
Well, frankly, I think the bar should stay out of it. I don't know that the bar has a role.
And why not?
Well, I think that the way the people set the Constitution up, it's not a sin to oppose or retain the retention of a judge. Now, I think individual members of the bar could have a point of view on this, but I don't know why the bar would.
Even if you have, what we've been talking about, I think, here today is we're seeing new things that we've never seen before, like unprecedented amounts of large money coming from out of state, not our state citizens trying to speak up about, judicial policy making, but instead outside interests who are upset about decisions that are, in fact, I believe it's a number of the cases that are currently pending before our courts. And they want to impact the outcome of cases pending before the court now. So
I think that's inherent in a retention election. I think that's understood when the people approve a constitution with retention elections.
Yeah, I do think that the state bar, in Arizona, when our state bar was talking about this, and I hope I'm not misrepresenting the state bar, I don't see anybody here from a leadership position there. But what they decided was, the question was whether the attack was on the system because of substantive decisions that were made by the court, whether it was an attack on the court for doing its work, or whether it was an attack on an individual judge. The individual judge, our state bar agreed that this is part of what a retention election is. But when our state bar felt when the attack was on the system, because judges were doing their job, that was something that the state bar had an educational role in and could talk about with the public. As individual judges, they agreed that was kind of up to the voters, that's what it's for. But that at least is one experience. I don't know whether you have judicial performance evaluation in Florida.
we don't.
Yeah, you might think about, this really.
I wrote that note down.
Yeah, it really has been very useful, not only in Arizona, but in other states, because you have a real honest evaluation of a judge made independent of campaign rhetoric by people who actually appear before and know the judge. And that can be very useful in combating some things like this from people who come from outside who really don't know very much about your judges, just about their point of view.
And just to tie that to something that Justice Kelly said early on in terms of the recommendations of the commission in Michigan, this issue of voter roll-off, it's often called, where good voters will come to the polls and stop when they get to the judge. We actually, our group commissioned focus groups to sit down with some of those roll-off voters. These are people who voted every presidential election, they vote for Senate, they vote for city council. They think it's very important to vote, and they stop at judges, and we ask them why. And in fact, they said, we don't have the information we need on the judges, we don't really know how to vote for a judge, we think it would be bad civics to vote for a judge when we don't know why. And that does lead to rather low voter turnout in a lot of these races and does open up a vacuum for interest groups, sometimes out of state, to figure this is a pretty easy race to push our way around in.
I think both of the questions thus far, in my mind, elicit the same response, and something I mentioned earlier. What we need are judges of courage. Look no further than the Iowa court experience. The 5 largest expenditures came from out-of-state groups. They're the ones that led it. And I think it is likely that those kinds of attacks are meant to and do intimidate judges. When you make decisions on a court of last resort, your Supreme Court, you know that there can be consequences. Look at Rose Bird in California, for those of sufficient vintage to remember that election. Now, that was the death penalty. Penny White, that was the death penalty. The 3 justices from Iowa, that's same-sex marriage money coming in from out-of-state contributors. One issue, folks. Every time you write a dissent on what's oftentimes a dissent favoring hopefully favoring the Constitution, but viewed as favoring criminal defendants. You know that there may be consequences cumulatively to that. And so what we need are judges of courage, but we also need members of the public and attorneys of courage, people who are willing to stand up, people who know about the rule of law, who think thoughtfully about the importance of an independent judiciary, to stand up and have your voices heard. Now, you might be organized together in a group like the Bar, as Justice McGregor made the point, the difference between supporting an individual justice and the support that an organization can give when that justice is being attacked for doing his or her job. I think that's an important distinction. But I don't think you have to wait until a bar organizes. I think absolutely every single person in this room, if you're going to demand from your judges to have the courage to stand up in the face of those kind of frontal assaults, then you better start standing up too. And I think of no better place than right now to show my eternal gratitude to Justice at Stake for standing up and being that important voice time and time again. You know that people, that organization cares, regardless of if you always agree with them. They care. They're standing up to have their voice heard. And every single person in this room should not excuse himself or herself from that obligation either.
Let me mention, I have a report here by Justice at Stake and the Brennan Center for Justice at the NYU School of Law, and they do report this on Florida. And they say, Florida, court splitting or court packing, that apparently the Speaker of the House aggressively pushed a plan to create separate panels for civil and criminal cases. But there's always a hidden agenda, and in this case, the hidden agenda was that it would give the state's Republican governor 3 new justices. However, only 2 states in the country, Texas and Oklahoma, have such bifurcated systems. And in Texas, a Supreme Court justice in 2011 castigated the split system as archaic and ineffective. And so watch out for those hidden agendas, and it's just a plan to kind of pack the court like Roosevelt tried to do with our Supreme Court many, many years ago.
So is there a question over on this side of the room, not to ignore any hands that may be up, maybe not? Okay, let's turn back over here. I see a couple hands in there. Why don't you pick somebody out, just because, again, I can't quite see who else. Back there? Oh, I'm sorry, you've got one.
There's
More of what I can't see.
Yeah, thank you so much for this. I have a question for Justice Taylor, and I hope I'm understanding your comments properly. But you mentioned that the work of selection commissions can sometimes be a wash, because I think you said that the candidate pool was so uniformly highly qualified that drawing meaningful distinctions became a very difficult thing to do. So if that's the case for those commissions that are carefully selected with leaders of both parties and prominent thought leaders in the bar, if we can't have confidence that they can draw those meaningful distinctions, is there a reason that you feel that the general public can draw meaningful distinctions?
Well, my sense of this is that what I wish to indicate in my remarks was that merit selection is sold on the basis that we will be picking judges based on their credentials, sort of nonpartisan things, smart people with good academic and practice records that have been outstanding citizens in their communities and so forth. And my point is that almost everybody in the pool, certainly all those who are being considered to be sent to the governor, be they 3 or 5 or whatever, will have that set of credentials. Otherwise, they just don't apply. So failing to be able to meaningfully discriminate on credentials, they default to whether or not they agree with them on contested issue matters. Is this person right on abortion? Is this person right on same-sex marriage? Is this person right on 1,000 other things? Are they right on the power of labor unions? Are they right on the auto insurance laws in the state and so forth? So I think that that's the point I wish to make. Now, at least when there are systems which are at the end accountable, and I'm here thinking of, say, the federal system, or perhaps even just gubernatorial appointment without Senate confirmation. I think that those systems do lend themselves to a broader group of people making this decision, for better or for worse. No system is foolproof. No system can guarantee that only good people will go on the bench. So I think we have to take the one that gives the best chance for people who are capable and qualified in the sense that the people would think it is qualification that is being looked at to get there. I might add one other thing. I think it's really important to think about the notion that a contribution is purchasing the candidate. I have never seen that in Michigan. I raised a lot of money. Justice Kelly raised a lot of money. I never thought of these things as purchases. And frankly, I don't think my donors did either. And I don't think hers did. Yet the predicate of all of our discussions here today is that contributions are purchases. And I would remind you, our system, as set up in 1789, is a system where the people govern. The people govern through elections. Elections invariably are going to involve contributions. You can't have them otherwise. So I think we need to be careful to not run head-on into the very most fundamental traditions and institutions of our society, which has been the envy of the world since the time the Constitution was ratified.
So we have time. I'm sorry. Want to add in, please?
Let me just mention that, with all due respect, I'm going to have to disagree. You know, Justice Stewart Pollard said, fairness is what justice is. And fairness is integrity, neutrality, and not prejudgment. Because if you come in with certain mindsets on any issue, then I think you probably should recuse from any case that is going to have that issue, because you've already made up your mind without even, giving the law and all sides an equal opportunity. And you just have to keep an open mind and base your decision on the law and on the Constitution and on fairness, because that's what justice is. And not on prejudging same-sex marriage or anything else. That, to me, is unfair.
Justice Kelly?
A brief word. Even if we are to assume that every single judge and justice has been able to set aside all campaign contributions and their influence on every case that judge has judged, we still have a problem of the public's perception that they don't and can't. And if the public doesn't believe they're fair and independent, the system isn't working properly. And that's the ultimate problem with the big financial contributions that are unidentified.
So we have time for one more brief question and probably just a brief answer. Right there with the red cuff. I can't even quite tell. Right, you glasses, yes.
While I agree with Justice Taylor on the general desirability of elections for some of the reasons he's articulated, I'm wondering whether the source of the influx of big money is not being identified correctly. Big money comes from people who have a lot of money. And the primary culprit, if you will, in this has been, to name a name for as an example, the United States Chamber of Commerce comes in from out of state without identifying their donors. And this seems to me to have originated way back when Justice Powell was general counsel for the chamber and wrote that famous memo. From that point on, the chamber has become a lot more aggressive about entering the fray, be it legislative, executive, or judicial. And why? Usually not because judges have entered the legislative fray, but because they wish to have judges nullify what juries have done as an economic issue. Isn't the chamber really one of the main malefactors, if you will?
They could be. Let me just supplement what you're saying, though, to say that I think groups on the left, trade unions in Michigan, wish to nullify what the legislature has done oftentimes. I think groups on the left want to have an expansive reading of provisions in the Constitution of Michigan, which have heretofore not been read expansively, to get things accomplished that they would like to do. I suspect we haven't seen this case yet, but I suspect same-sex marriage is the kind of case that we're talking about. So I think both on the left and on the right, they have agendas. But the big trick is they never thought before they could get them through the courts. And they have now come to the view that they can get policymaking done there, and it's so much easier than doing it in the legislature. One trial judge, 2 Court of Appeals judges, 4 Supreme Court justices, and you've got bulletproof policy. And I think groups on the right and the left have figured this out. I think the answer here isn't to deny that this is what is going on. I think the answer here is to consider whether courts should return to the more reserved role that they had historically.
So, as the only member of the panel up here who's neither elected nor selected, I am nonetheless given the power and the authority to say that our time, unfortunately, has run to a close. And before I ask everybody to join me in thanking an extremely distinguished group, let me just sort of reflect here. Excuse me. I'm very glad everybody came. This isn't always an issue that you see on the program and you run in when there's a healthcare panel down the hall. This is the biggest democracy issue that most people have never heard of. What's going on in the courts that decide 98% of America's cases, and you've heard a terrific discussion, a terrific debate at times. And let me just add as well that there are a number of organizations, ours and some of the others mentioned, on all sides of the issue that care about these issues, and I encourage you to look at our websites, to look at the publications. This is a huge issue going on under a lot of people's noses, and everybody who cares about the legal system, which means everybody in this room and a lot of people you work with, would do well to just keep an eye on it, learn more about it, stay in touch with terrific people like these. These are the educators, and if more Americans spent the time that you all do caring and reporting about the system and educating Americans, I'm not sure we'd be talking about the idea of a crisis of confidence in the court. So please thank me in joining an excellent group of panelists.